So I want to introduce you to someone called Flash Shelton. He's a California man who's helping landlords recover possession in an interesting way. He's turning the tables on squatters. You're learning all about the squatter hunter today. Let's get started. Now, you might have heard me talk about self-help mechanisms in the past. For those of you who've watched my channel for a while now, you know that I am a Texas attorney. What Mr. Shelton is addressing is the issue that really there aren't a whole lot of laws that address when a person has taken possession of a property through illegal means. A squatter has the same possession rights as any paying tenant. He's developed a plan for squatting on the squatter. So the way Flash tells it, in 2019, when his father passed away, his mother had some property in Northern California that was suddenly taken over by squatters, and she didn't know what to do about it. He took it upon himself to get rid of the squatters, but he didn't use the courts. He didn't send a notice. He didn't institute an eviction. Instead, he had his mother write a lease. And in this lease, Flash was her tenant. And so as a tenant, he walked in and he sat down and he took possession of the property. Now, his thinking was pretty simple. If I'm here and I actually have a lease, even if you have a lease, you certainly can't prove that it was signed by the actual owner, but I can. And the truth is, he's technically right. He entered in by operation of a written document that gave him the right to enter and to possess the property. The question is, what are the legal ramifications of this? Well, he's not the landlord in this situation, although you could make the argument that he's acting as an agent for the landlord, but we're not going to go there for now. He stepped into the property and assumed possession, and he did so strategically. He waited for the occupant to leave. He stepped in, changed the locks, added cameras all over the place, and then took all of the occupant's stuff and put it in the driveway. What legal right would that illegal occupant have to reclaim a right of re-entry? They might go to the court with their lease and say, I have a superior right to possession over this guy. He is committing a crime. You can tell because now all of my stuff is outside. Well, what would the local authorities do? Typically, whenever the police are called to a scene like this, they're very hands-off, and they'll say something to the following effect. Look, you've got a civil claim between you. I'm not going to interfere. Take that up with the courts. And if that's the case, well, you find yourself in the exact same position where you wanted to avoid the courts, and now you have to utilize the courts in some way in order to prove your right to stay, or in order to prove your right to exclude somebody who once had possession of the property. Now, I'll tell you one thing that I don't mind is you squatting on this YouTube channel. If you like what you see, please give us a thumbs up. We appreciate that a lot. Any questions or comments? I'm going to answer those myself. So how might a court address these facts? Well, the former occupant has an opportunity to present an emergency case to the court in which they will display a contract. In that contract, it'll say, occupant has the right to possess, signed landlord. Now, in this case, you have a competing lease because Flash has a lease signed by the actual owner. And sure enough, if the illegal occupant goes to the court, sure enough, Flash is going to be there, and he's probably going to bring the actual owner, his mom, to that same proceeding. And the court will have the opportunity to weigh the equities. Well, who has the actual right to be there? However, if the determination is based on current law that the illegal occupant was occupying the space first and established occupancy, the only way for Flash to establish his own superior right over the illegal occupant would have been to remove him. And the facts of a case like this at this point are moot. If that illegal occupant is gone, he no longer has the right to make this emergency plea, but he could have if he knew what he was doing or if he sought legal counsel. And I know what you're thinking. It's like, Ernie, I don't get it. Why is this even allowed? Well, partially because the courts favor possession over kind of vigilante action. But would that make Flash and his mom wrong? Not in the eyes of the general public, but maybe in the eyes of the court. Essentially, what Flash did was a good deed in a bad way. It's a way that, just because the laws are not caught up to the reality of this social injustice doesn't mean that it's okay for someone to take the law into their own hands. Flash is actually lauded as a hero in many, many respects, but the courts may not agree, and all it would take is one incident where Flash is prohibited from this sort of thing, and that could be repeated in every other court where he attempts this same self-help. So reportedly, Flash Shelton is offering his services at a minimum rate of $5,000, where he'll go in, he'll take that same lease from an owner that he'll use to justify going into a house where a squatter has occupied it. He'll set up cameras and essentially occupy the space in a way that kind of nudges out that illegal occupant. He says this is him squatting on the squatter. He goes in and takes possession and essentially makes it so uncomfortable for this other person that they voluntarily leave. But what happens if they're cool with it? What happens if they never ever leave? Can he, like the first time, gather their things and simply put them out on the curb? Well, the truth is no. In fact, he probably didn't have the right to touch that other person's things the first time. And as long as the law has not caught up to this reality, I don't think he can pull that off again. And the more that people understand what he's doing, the less likely he's going to be able to continue doing it before the laws have changed. One other key factor is something that Mr. Shelton has actually acknowledged, which is the risk that he puts himself into by entering a property in this way. By squatting on the squatter, he agrees to put himself in harm's way. He puts himself into a situation with a slight unknown. He claims to have investigated the situation to mitigate his risk of harm, but you're going in and occupying space with somebody who might feel physically threatened, who might actually have a gun, who might use physical force to get rid of you. And the fact is, if someone implements some kind of physical force, would they be fully justified in it? Because even if Flash can show that lease that is signed by the actual owner, he's not in possession until he's actually moved in. And during the process, he may actually risk physical harm to himself or possibly to another party. What would happen if, for example, an occupant, while Flash is moving in, fires a weapon and shoots some other party? Would that resulting physical harm or even death in any way be Flash's fault, knowing as he does that there is risk of physical harm? Again, the fact that he has a lease, the fact that he has the permission of the landlord to be there, doesn't mean he wouldn't have some kind of culpability. And additionally, the landlord might have culpability in the event that another party, an innocent victim, is harmed in the process. The issue of risk may itself be the reason why any landlord who undertakes this kind of self-help is opening a Pandora's box to all sorts of liability. How would a person's insurance be affected in this way? Would the insurance policy even cover this event of some unknown third party being injured in this set of facts? Remember, a landlord is willingly signing an agreement with someone who they know is putting themselves in harm's way, essentially creating a pretty dangerous situation that knowing creation could create all sorts of liability for a landlord. I don't know that I would ever recommend creating a situation that implements this kind of risk. If you're already being charged thousands of dollars for a service for somebody who's, again, crazy enough to put themselves in harm's way, you really got to ask yourself, is it even worth the money? Remember that the judicial process is already in place to address this situation. If it turns out that someone is claiming that they have a lease and their basis for remaining on the lease is this written agreement from some other party, here's how I would address this situation. You show up, but not in person. I don't ever recommend that someone put themselves at risk of physical harm when someone else is clearly occupying the space without the owner's knowledge or consent. You show up instead in written form, as I always suggest. You send written notice to the current occupant and you say something to the following effect. I am the owner. It appears that you are occupying my home without permission. If you claim to have permission, I hereby nullify that permission because it was given to you without my consent, my knowledge, or my approval. You are hereby on notice that I seek possession, and you are hereby notified that you must vacate. So by establishing for the illegal occupant that they are not allowed to remain on the premises, you lay the foundation for a future eviction. But you could change things in other ways. You could, for example, let them know, by the way, if you remain in place, you now owe me whatever rent you agreed in your lease to pay. Come next rental period, I expect to receive that rent. As the actual owner, you are the owner of any contract associated with the use or occupancy of that premises. As such, if you don't get rent, they don't get to stay. And if you sue them for non-payment of rent and they show up with their lease, which they didn't pay to you, guess what? Now you can recover from them potentially money damages for the unpaid portions of rent. Now, would a court actually go along with this? Maybe, because you have presented now a legal argument to non-payment where they're claiming they had a written agreement to make some sort of payment. That's your money, not the fraudsters, if that's their claim. Oh, I'm the victim here because I signed a legitimate lease with some third party who fooled me. But once that person is on notice that the actual owner is now demanding payment, if they continue to act with what they claim is a fraudulent party, I don't know that they have any protection for that. And you might set up a situation where now you're entitled to a judgment because that person didn't properly pay rent to you, the actual owner. Additionally, you might prevent a further appeal unless they willingly pay into the court's registry or to you the amount of rent they claim they are fully willing to pay. In any case, you can set up the eviction through the normal course of the normal rules for your state and not put yourself or any other parties at risk through some self-help mechanism. You definitely want to send notice. You definitely want to put that occupant on notice that any future rent belongs to you and should only be paid to you, and that their unwillingness to either A, contact you, or B, move out will result in an eviction. And in that eviction, you're going to seek the maximum allowed by any court against them. I often talk to landlords about the box because it's popular to think, well, if someone's thinking outside of the box, then that's definitely the best way to think. But let's not get rid of that box too quickly. That box is there for a reason. It's been around for a while, and the box works. Sometimes when we think outside of the box, we actually, as clever as the idea might seem, open up all sorts of other boxes that are risk. And when you haven't considered each of these risks, you sometimes fall prey to just another bad idea. And you don't want to do that. Definitely, if you're interested in recovering property, whether it's from a tenant or a squatter, make sure that you've consulted with somebody who knows the rules of the game and who has considered each of these risks. If you're getting good information from a good source, you're likelier to spend good money for a good result. Again, I applaud creative thinking, but let's not be so creative that we're creating risk unnecessarily. If you've enjoyed this video, and I hope you have, make sure that you check out all the rest of our content on this channel. YouTube seems to think that this video right here is absolutely perfect for you. Watch it and all the rest of our information on our YouTube channel. And until next time, landlords, happy